Welcome to literary and jury charge practice. Let's start with this narrative answer. Ready? Here we go. I would say, well, this is just a guess or something. I have never had any real communication with Reed at all. It has always been with the general contractor. I would say that all my communication was from the general contractor. I was told to get the job done and to get the tile finished. There was something about opening the building and doing something by the beginning of the month. I remember that. This whole court thing is bringing it back to my mind. I'm starting to open up and think a little bit. Whenever there was an industrial accident, we had told our secretary to notify the industrial board and the insurance company. I assume she filled out all the paperwork. I think it happened on a Tuesday, so it was like 3 days or 2 days after the accident before I got out there. I was curious to see where he fell because, from what I understood, it was near the main entrance to the mall or something like that, and he hit his arm on an elaborate wrought iron fence that was around there. When I got out to the site, they had zoned off the area with the wooden barricades and with those yellow warning ribbons. The scaffolding had been removed, but you could still see where it had been braced against the side of the building. All of the tile was just where he had left it. Short little warm-up there. Now we'll try a little jury charge. And this is a criminal jury charge. Ready? Here we go. The defendant is charged with the commission of the crime of robbery. The crime of robbery is the taking of personal property in the possession of another from his person or immediate presence and against his will, accomplished by means of force or fear and with the specific intent permanently to deprive such person of the property. These are special allegations that were charged against the defendant, and you will receive special instructions in that regard. In this case, the specific intent to commit robbery and the commission or attempt to commit such crime must be proved beyond a reasonable doubt. If the human being is killed by any one of several persons engaged in the perpetration or attempt to perpetrate the crime of robbery, all persons who either directly and actively commit the act constituting such crime, or who with knowledge of the unlawful purpose of the perpetrator of the crime and with the intent or purpose of committing, encouraging, or facilitating the commission of the offense, aid, promote, encourage, or instigate by act or advice its commission, are guilty of murder in the first degree, whether the killing is intentional, unintentional, or accidental. Murder of the second degree is the unlawful killing of a human being with malice aforethought, when there is manifested an intention unlawfully to kill a human being, but the evidence is insufficient to establish deliberation and premeditation. If you are convinced beyond a reasonable doubt that the crime of murder has been committed by a defendant, but you have a reasonable doubt whether such murder was of the first or of the second degree, you must give the defendant the benefit of that doubt. And for a little more jury charge practice. The subject of this jury charge we've been working on, supervisory responsibility. Ready? Here we go. What are some of the things that a foreman or supervisor can do to create such a situation? How do other people want to be treated? They expect direction and support from the foreman or supervisor. They want to know what is expected of them and to be given the necessary assistance in achieving the required goal. They also want to be accepted and respected. The supervisor is pleased when his superior gives him recognition for a job well done. He expects criticism when his work is not satisfactory, but he would like it to be constructive and he would prefer it to be given in private. The men who work under the supervisor have similar needs and desires. They want to feel free to make suggestions and offer criticism about the way work is handled, and to feel that their suggestions will be given serious consideration. They want, in other words, to be treated in a democratic manner. Learning the principles of good supervisory practice is relatively simple. Applying them in the everyday work situation, however, is often not so easy. One of the main difficulties is that on his job the supervisor is dealing with people rather than principles, and people are much harder to understand than abstract principles. They are much more complicated and they have feelings and emotions. Sometimes a worker brings his personal problems to work with him. They may involve financial worry over a member of his family who is sick, or any one of the thousands of lesser troubles that are apt to make a person feel out of sorts and unable to do as good a job as usual. This does not give him a license to be disagreeable, nor does it excuse poor work, but he can feel that his supervisor sees him as a human being, not just a work-producing machine. He will be better able to maintain a proper perspective. When we recognize that other people have problems and do not take their resulting gruffness personally, we help to maintain good relationships in the working group. But there are some situations that call for special handling. Every foreman and supervisor knows that there are workers nobody can seem to handle properly. They are the chronic absentees and the men who stir up trouble with other fellows in the shop. Selected studies have shown that more people are discharged from their jobs for social than occupational incompetence. It was not the inability to do the work. They just could not get along with the other people on the job. What can the foreman or supervisor do if the usual disciplinary measures do not work? He knows the worker has a family to support, so he tries to overlook some things, or to talk to him like a Dutch uncle and give him some good advice. Sometimes this just makes things worse, and the time soon comes when the man must be discharged in order to prevent chaos in the shop. The moral of the story is plain. If a man tells you he has a severe pain in his lower right abdomen, you don't try to treat it. You suggest that he go see a physician. Similarly, you are not a psychiatrist and you have not had the training to treat people with emotional problems. Trying to be an amateur psychiatrist usually results in drastic trouble for you, the man you are trying to help, and everybody around him. The best thing to do in such cases is to refer the man to someone who is professionally equipped to help him. If you work in a larger plant, there probably is an employee counselor who knows about the resources in your community and who can make arrangements for professional help. Refer the man to the employee counselor. Some plants have staff physicians and even staff psychiatrists who will be able to help the man discreetly. If your plant is small and does not have these facilities, you can suggest that the man see his family doctor, who will know how to handle the case or make arrangements for special care. This business of referring an emotionally disturbed person for special treatment may sound like a simple procedure. Actually, it is not. It takes a lot of tact and understanding. The basis for making a good referral when a man needs help with his emotional problems is the same as in setting the stage for a mentally healthy work situation under normal conditions, and that basis is mutual respect and understanding. We are all trying to get along the best we know how. The other person has the same kind of feelings we do, so in looking for the best time or way to suggest that a person with serious problems seek treatment, try to put yourself in his shoes. How would you like to be approached on such a subject? What would make you feel more comfortable if you were in his position? What would be most likely to convince you that your boss was really interested in you as a person and that it might be a good idea to see a doctor? All this is much easier, of course, if you have already established a good personal relationship with the people working under you. You know and respect them, and they know and respect you. Furthermore, they feel comfortable about talking freely with you about things that trouble them. When the problem seems to be one that the man can't find an easy answer for, you can suggest as tactfully as possible that he might want to talk to an expert who could give him help. This good personal relationship between the supervisor and his men, which is the basis for making a proper referral in the case of an employee with emotional problems, is really what we have been discussing. In such an environment, men can work together harmoniously, and yet each man remains a separate individual with his own individual differences and his own unique personality. This is of primary importance. We cannot expect men to become mere cogs in a machine and still be men enough to be able to run the machine. All right then, now let's try some literary material. And we will continue on with our literary called Not All Gas is Created Equal. Ready? Here we go. Last year, AAA hired an independent engine testing lab to see if top-tier gasoline cleans engines any better than non-top-tier brands. The result, top-tier gasoline averaged a whopping 9 times fewer deposits than top-tier gasoline after only 4,000 miles of simulated driving. And for motorists who've been using lower quality gasoline, the AAA study had good news. There's no need to tear down the engine and decoke. As stated in the final report, engine carbon deposits formed when using non-top tier gasoline can be largely removed by switching to a gasoline that meets top tier standards, though it may take a few thousand miles of driving. More good news, the average price difference between top tier and non-top tier brands was just 3 cents a gallon. AAA also found non-top tier gasoline reduced fuel economy by 2 to 4%, meaning that the higher cost of top tier brands is mitigated by improved fuel economy. Seems to me like pretty good reasons to stick with top tier gas. A note of caution, don't confuse gasoline quality, which refers to detergent additives, with grade, which refers to octane rating. Buying a lower octane rating than specified in your car's owner's manual also harms performance and could cause engine damage. Buying a higher grade when required is a waste of money, but that's the stuff of another column. Now we'll get started on a new jury charge, and the subject is automobile accident. Ready? Here we go. Ladies and gentlemen of the jury, before I actually get into the charge itself, I think I ought to say to both the gentlemen who have appeared here in this case that I fully appreciate the way in which they have conducted themselves throughout the trial. It made my task so much easier. My task, as you know, consists to a great extent in presiding at the sessions of the trial and maintaining decorum, in keeping the trial going without any undue delay, and making such rulings as may be required while the trial goes on, particularly in ruling on the admission of items offered in as evidence. And now the last portion of my duty consists in outlining for you the rules of law which obtain in this situation, and which are to be your guide in performing the final act that you are to perform. You must understand, as you have been told time and again, that in this field of law I am supreme, that is, at least as far as this courtroom is concerned. If I should make an error in stating the law of this case, there are courts of review that exist for the purpose of correcting me. It is not your function to try to correct any error that any one of you may think I am making in telling you what the law is, nor is it your province to disagree with the law. If you should decide the law is bad in any respect as I give it to you, you are duty bound under your oaths to accept the law as I give it to you and to follow it. Similarly, you are supreme in a field of your own, the field of the facts. Whatever you do with respect to the facts is not to be interfered with by anybody, least of all by me. You are to decide this case after listening to it all these days upon the basis of the evidence and the evidence only. The plaintiff's claim is that because of defendant's negligence, to which she did not contribute in any way by her own negligence, she was struck by the police automobile, and as a result thereof she was injured in several different ways, all to her damage. She must prove her claim by what is known as the burden of proof. There are certain matters as to which there is no disagreement. Everybody agrees here that she was hit by the car. There is sharp disagreement as to certain of the circumstances which might or might not spell out negligence on the part of the defendant or contributory negligence on the part of the plaintiff. Everybody agrees that she sustained certain injuries. There is rather sharp disagreement here as to whether some of these claimed injuries resulted from this particular accident or were the result of something else which had no relationship to the accident. You see, you must carefully examine these steps all the way until you finally reach the conclusion that I will point out to you. What is meant by negligence, a word that you have heard mentioned by both counsel and the court. You can well understand that in the active and crowded society in which we live, if we did not have certain rules of conduct, people would interfere with others to such an extent that life would not be livable. Each of us must live his life in such a way as not to interfere unduly with the lives of other people. For that purpose we have set up certain standards of conduct, one of which is called a standard of care as to what should be done by reasonable people in a particular set of circumstances to prevent or to avoid harm to another. Failure to adhere to this standard of care as the result of which injury is caused to someone else is what we call negligence. What is reasonable care? That varies in accordance with that particular circumstance involved in a particular case. There might conceivably be an entirely different standard of care in every particular set of facts if you change one of the surrounding circumstances. We are only interested in this case in the standard of care which should be observed by reasonable people under the particular circumstances in this case, as you find them to be, and in nothing else. This standard of care in any case is a question of fact for the jury to determine. Plaintiff claims that the driver of this car was negligent. I want you to understand, so that there is no question about it in your minds, that if this policeman in driving this car was negligent, it must be attributed to his employer, in this case, the defendant city of New York. Quite obviously, the city of New York cannot drive a police car. It must have employees to do so. You are to determine precisely what you think happened, but you are persuaded happened, what is the greater probability as to what happened, and then make your decision as to what was the standard of care that reasonable people should have observed in the circumstances, and whether or not there was adherence to or departure from the standard of care. When I speak of contributory negligence, there are certain things which are applicable both to negligence and contributory negligence. Contributory negligence is defined in almost the same way as negligence. Before you can find contributory negligence, you would have to find that there was an act or an omission on the part of the plaintiff which was either the cause of the accident or a contributing cause thereof. Our law says if one by his own negligence contributes to the happening of an accident, even in the slightest degree, a defendant is thereby exculpated. A defendant cannot be held accountable unless you find that this plaintiff was free from contributory negligence. Even if both sides contributed to the happenings of the accident by negligence, you must find in favor of the defendant. The use of an automobile requires certain standards of care to be adhered to. There should that should be quite obvious. One cannot just go driving an automobile about the streets of a city like this without any regard for the fact that there are other automobiles on the road and that there are other people. To do so would be quite unthinkable. The operator of an automobile has a positive duty at all times to have it under control, a degree of control consistent with all of the surrounding circumstances, that is in accordance with reason, and as part of that he is charged with the duty of foreseeing those dangers which one might reasonably be expected to foresee under the particular set of circumstances that apply in that case. And that will conclude our literary and jury charge practice.